All right, we are live. Good evening, everyone. Thanks for your patience. Lots in the waiting room, slowly trickling in. We've got a fantastic course for you this evening and appreciate your time. All right. As the waiting room clears through, quick audio check. We'll get started in about 30 seconds. Perfect. Great to see some friendly names here this evening. And the man with who needs no introduction, Paul Martin. Thank you again, Paul. We know how much you've got going on right now with the courts and clients, and truly appreciate all your time for your clients and my clients alike here tonight.
No, thanks for having me, Eric. I'll always make time for dentists and for Sarah's, of course.
Appreciate it. For those of you that don't know, Paul is an incredible speaker and also truly, as you'll see from the updated court cases, the person that is probably the go-to resource for dental employment and regulatory type of litigation across the country. Paul, for those of you that don't know him, provides incredible civil litigation representation, right, and advice on a broad range of matters from business to individuals, right, with a specific emphasis on employment, labor, commercial litigation, professional discipline, and health law, just to start. Really, he's in front of the courts quite a bit. So in terms of precedent, in terms of cases, and some of the recent trends we've seen, is pretty remarkable. And Paul's going to touch on some of that this evening. In terms of that, Paul's a huge believer, as we have over the years, to help with that individual approach. Every doctor situation is a little unique. And certainly now, as we look forward, everything, if there's one consistency, it's that it's change. Paul, I know you're going to cover a lot of some of the updated cases and whatnot, but maybe from a 10,000-foot view, what are you seeing in terms of trends, situations, and/or maybe some high-level advice you're giving to your clients as they're watching the news and tariffs and changes and certainly Canadian dental plans in Canada? Maybe at a 10,000-foot view, what are you seeing across the board?
Well, luckily, I suppose as of now, I don't think any of the tariffs have impacted dental offices too much. So I haven't seen any downsizing like I've seen in other industries in relation to that. Probably the most important thing that I'm going to go over this evening is some cases that have come out recently where the courts have once again illustrated a distaste for certain types of employment contracts and how that can expose dentists. So one of the big trends we're seeing is a case that came out just at the end of last year that's really impacting how we draft employment contracts for dentists. And also every dentist I speak to, I'm telling them you've now got to go under the hood again and look at your contracts because they might need an updating. So that's what I'm going to focus on this evening, and I'll get into it in much more specific detail.
Perfect. Appreciate it. For those of you that haven't joined one of our sessions before, welcome. The whole premise here is to remind the dental community you're not alone in all of this. And when it feels like it's so incredibly difficult to be an entrepreneur, let alone be a dental clinic owner, it's a great reminder that there's fantastic resources such as Paul out there to be able to have an initial conversation with, get some fantastic guidance. And if things do escalate, right, obviously there's no one better that you want to have on your side. So from that perspective, right, let's do really tonight, the goal is an empowerment piece. For those of you that haven't joined one of our courses before, again, welcome. My name is Eric. I'm the owner of Sears Consulting Group. We're pretty unique across the board where we've had the privilege of working with many of Paul's clients over the years where we facilitate a pretty unique need as a consulting business. We are remunerated directly by the dentist, no different than Paul. And then really where we focus on is we want to help to ensure that First of all, versus the local broker, etc., you've got someone in your corner that's being paid for by you that's helping to negotiate the financial court clauses. And then number two, one with the experience that has dealt with landlords from coast to coast to coast to coast, right? And now Cirrus is proud to be in their 31st year in business, having the privilege of supporting over 13,000 doctors over a 30-year history. So the data is key, the reputation, and more importantly, realizing that doctors, you are one of the best tenants on the planet. You've got some of the highest build-out costs. You've got some of the lowest default rates. You're in the same location for 26 and a half years, right? And you're COVID proof. You can't work from home regardless of what your staff says. And certainly always bringing in high quality foot traffic. Yet unfortunately, what we see from time to time and time again is that doctors, and over 54%, are overpaying in rent. Well, why is that? If you're the best tenant yet paying such high rent, why? Well, yes, there's high build-out costs, so the landlord can perceive to squeeze, but in many cases, it's not leveraging your leverage or the data. So, where it's from being incorporated since 1994, we now have access to over 95 billion square feet of data. So, as it pertains to demographics, rental rates, vacancies, comp reports. As we've helped some of Paul's clients in the past, let it be through relocations or expansions or just simply lease renewals, understanding what the rental rates, vacancies, and comp reports are huge because, right, the question we typically ask is, when was the last time, doctor, you compared your rent to market price? Right? No different to, or when was the last time you had your lease reviewed for red flags, demolitions, relocations? Paul's really going to stress this evening the importance of the employment contract, the importance of having the employment contract reviewed. And I'm sure many of you will be shocked to realize that because of recent changes, it has impacted the validity of some of those employment contracts. Not to steal any employment thunder, but it's certainly a challenge, one entrepreneur to another, to always try to stay ahead of it. The data, though, right? Rental rates, vacancies, comp reports, these sorts of things is a perfect perspective to understand. Is now the right time to expand? Is now the right time to look at a second location? I've already sold my pediatric practice. I'm now contemplating next steps or maybe a second location in the future. Don't underestimate the financial impact. So, simple numbers, we typically run a pro forma analysis for a lot of our clients that just looks at base rent, annual increases, common area maintenance, etc. But just looking at a monthly rent example of 5,000 with a 3% annual increase, right? It's almost a $3 million financial commitment over the next 30 years. The purpose of sharing this is the lease represents a check, the biggest check that you will sign in your personal and professional careers, full stop. So therefore, if you're about to sign a $3 million check, right, does it not make sense that you've got someone on your side to help squeeze every drop out of that lemon and make sure that you are getting the best financial, right, and helping to minimize a lot of the other risks that may be hidden in that lease agreement, which we'll touch on. Um, so reiterating a few key points is, again, empowerment. You're not alone in all of this, right? You are a great employer. You go above and beyond for your staff, right? You remain compliant across all these components. It is so incredibly difficult to be an entrepreneur in the country of Canada or otherwise, but, really use that as a point of strength, right? Realize how valuable you are to the landlord and realize some of the key best practices that Paul will touch on and ourselves as well to help maximize your leverage, help to deal with tricky situations, and more importantly, how to do some proactive investment versus reactive cost is a big theme for this evening. So in many cases, don't underestimate what other landlords may be doing to entice you to move over to their space. We helped secure over $293,000 worth of tenant improvement allowance recently for a doctor to relocate. And she was incredibly pleased. One of our almost 500 five-star Google reviews that really did state that my landlord really wasn't helping me out where I was. For fun, we reached out to the landlord down the street, and it resulted, in a beautiful new building, which she knew she needed to build out because of pending demolitions, redevelopment, etc. Why is the lease and contract so important? So without throwing any legalese or otherwise, and luckily I'm just the business guy, is to understand leverage and negotiation. So again, you are a great value add to the landlord. They go to the banks to say, look at my great rent roll, look at my long-term tenancy. I've got this physician, I've got this dentist, I've got this massage therapist, right, with 10-year terms. That is a huge value add to the banks when they negotiate or renegotiate some of those mortgages. But it's expensive, right? These days, not uncommon to see across the country over $350 per square foot for build out costs. So the lease has become a very important component to redevelopment, and especially if there's a chance of demolition or the need to relocate to a different space in the actual building. And upwards, it used to be many years ago, Paula remembers 9 months. You either have a baby or you build out a new clinic. Now, these days, a full relocation could easily be 18, maybe even 24 months. And also, having worked with many of the top practice brokers and Michael Kuttner, otherwise on the merger and acquisition attorney side, is the practice sale. Michael, Paul, and I have done lots of lectures together, and the unfortunately, according to a lot of the practice brokers, one of the biggest reasons why a practice deal dies at the 11th hour or there's a significant swing in the valuation is because of the lease. So the more things that can be done to help prepare a lease, to make sure there's sufficient term, or if you're selling charts, you've got someone on your side to help guide you, advise you with some white gloves to ensure you're making the right decisions to maximize your eventual practice sale proceeds. And I'll go through a few of those ones today. At a very high level, in the essence of time, is what should it do? Why do we even need a lease? I was with the U of T fourth year students, Paul, and it was funny of a conversation to say, look, how much business of training, business of dentistry, right, courses have you had? There was a few core components, but in many cases, it's an element of, look, Eric, I just don't know what I don't know. So we're going to do a basics 101 business workshop type of thing, just to realize signing it in your name personally or putting it into your corporation. What does that mean? What impact does that have? Right? How do I ensure that I'm not overpaying in rent? How do I know that I'm by taking $100 per square foot in tenant improvement allowance isn't going to now lock me in for the next 30 years at ever increasing rental rates? One big takeaway is a great component is something called a death and disability clause. It is a specific termination right, which we're recommending. And if there's one big takeaway from today is to make sure you've got yourself a great perspective and protection. Because heaven forbid, let it be my godfather tearing his rotator cuff, or seeing the fact that so many doctors these days are unprepared for that emergency exit. Heaven forbid, if anything were to happen and you needed to sell tomorrow, could you? The banks today will require typically at least 12 years worth of term if they are going to, rule of thumb, give you 12 years or your buyer 12 years of term in preparation for sale. Therefore, term and options, if you are looking to sell your million or 1.5 or $1.2 million practice, that matters. There are so many ways that we typically help our clients and pay for ourselves multiple times over. Let it be through base rents, annual increases, common area maintenance, which is negotiable. Fixturing, free rent, tenant improvement allowance, landlord work. Again, great slide. These are just some of the different financial variables that you want to have help in the negotiation to keep as much money into your pocket as possible. Quick little example, but at a high level, if you don't know when your lease expires, has you signed it personally, and when is that option to renew deadline? One of the biggest things we see is some of the critical dates. And perhaps unlike the employment contract where you get it done and you put it in a drawer, the lease is something that is a little dynamic that typically every 5 or 10 years comes up for renewal and renegotiations. If you miss that, the remaining options become null and void. So the biggest reminder I can share with each of you is to start the lease negotiation. Typically 12 months prior to the lease negotiation is when that usual option to renew deadline is. In other words, if you signed a 10-year term, the landlord will typically require you to give them notice 12 months worth in advance. So therefore, we always suggest typically 2, in some cases 2.5 years prior to your lease expiry, meaning at year 8 is the best time to help maximize that leverage and help to ensure you're not overpaying in rent or agreeing to any terms, or the landlords now these days are adding in demolition rights. So this is one we worked on recently with Tier 3 that we've had the privilege of working with over the past probably 30 years. But this is a really interesting perspective. So this is $1 million worth of billing. This is a clinic in the GTHA with roughly $300,000 worth of EBITDA, profit, right, earnings. Now at a 6.2 multiple, right, at 182% of billings, it is with a clean lease with a long-term lease term, a $1.9 million valuation. However, on the far right here, you'll see because previously, right, a broker had locked them into a long-term lease over 15 years, and without knowing it, the landlord could substantially redevelop the mall, right? Didn't even say demolition. Tier 3 reduced the valuation by over $525,000 because of the risk that it brought on to the buyer and the bank's concern for the buyer that they would have to pick up and relocate. So that 525,000 represented the $350 per square foot risk that the buyer would buy your clinic and unfortunately have to move the next day. Now, even where it helps is even getting a 5-year deferral, as you can see, right, dramatically increases the price of the clinic to 1.6 million. The whole takeaway behind all of this, as Paul will attest, is a proactive perspective, starting processes as early as possible, great employment contracts with your employees, as well as a well structured lease and negotiation with the landlord helps to make sure Tier 3 can make sure, or otherwise can make sure, that you've got a great protection for that eventual practice sale proceed. One example, before I pass it to Paul, that's key is this. Take a quick second and have a look at where you might see some potential red flags in this one clause. Everyone but Paul. So this is pulled from one of the recent leases we've reviewed, and this is in over 75% of leases, right? From the many dozen people that are attending here this evening. First to be aware of is that you cannot sell your clinic without first receiving the consent of the landlord, full stop, right? You will not receive, you cannot sell your clinic without either A, usually conditional upon the lease being assigned and the buyer getting approved for financing. So a big reminder is, right, knowing full well that if your landlord changes hands or for whatever reason, if they want to withhold, delay, condition, or otherwise, right, that becomes very important. Number 2, and this is also in a lot of dental office leases that we review and my team reviews on a daily basis. In some cases, the landlord has the right, once you ask to sell, right, and transfer the lease and assign the lease from you to your future buyer. Number 1, the landlord could say no. Number 2, the landlord could say yes, say no, or number 3 is to literally terminate the lease on the date that you had requested to transfer the lease, i.e. the close of the sale. So, channeling my inner Michael Kuttner, these are the types of things that make the life of your merger and acquisition attorney a nightmare because it gives way too much control upon the eventual sale. So what some of the solution is to help remove, revise, right, and put some very clear pathways as to whom you can sell to and when. In addition to that, you certainly don't want to give any more control to the landlord that can then increase your rent. In this particular case, it can, upon assignment, well, hey, you've been getting a sweetheart deal, Dr. Martin. We can either increase your rent by to market or 15% greater than what you're paying today. Imagine going through the valuation and suddenly the landlord, as you're about to close, right, suddenly bumps the rent dramatically. So the preface here is how do we help to make sure that we are protecting ourselves and protecting ourselves from this? The one thing you always want to look through in a lease is for the word consideration. If the landlords, we are seeing more and more of this, so please talk to your practice broker on it. We are seeing more and more examples of the landlords requiring let it be key money or some sort of financial payment to transfer the lease from you to the buyer. There was an example in the GTHA where the landlord basically said no, right? We refuse to transfer the remaining two 5-year options because they were personal to the selling doctor. In other words, the existing doctor had the ability to stay for another 10 years, but those were not transferable to the buyer, right? Michael shared the story recently. The landlord finally, after all the back and forth and huffing and puffing, needed a check for over $100,000 just to transfer those two 5-year options. So anything here, this is another piece the practice brokers look at. If there's language that states something to the effect that if you are getting paid or part of your valuation is for the plumbing, the electrical, the walls, etc., anything that is affixed to the premises, the landlord says, aha, that is mine, right? Not yours. So be cautious, be very clear as to what is yours if you want to move, and or, right, is the landlord entitled to a percentage of those practice sale proceeds? We're seeing more and more of those across the country, right? Landlords are realizing you're selling this for $2 or $3 million. What's in it for them? Because their point is, right, what's your clinic worth without their keys? With that being said, last but not least, the big thing to be aware of is that even if you do sell, you shall not be released of your obligations under the lease and shall remain liable for any failure to the tenant or its assignees or subtenants to observe each and every final covenant. In other words, right, even if you sell to Dr. Smith, right, and Dr. Smith defaults, that can come back to you. So being aware of that, that is one of the biggest concerns. The seller wants to be free and clear and retire down south, right? And certainly the landlord typically refuses to do that because they don't know the buyer, maybe it's their first practice, and represents a consistent amount of risk to the landlord. The risk of this, obviously, here could be hundreds of thousands of dollars and dramatically impact the practice sale. A devastating example is a Dr. Amarnaz, personal client of mine. She tried to sell her clinic three separate times, and at 74 years of age, she was forced to relocate. So we helped her and advised her every step of the way, helped to locate a new location north of her clinic, and we're able to basically get the new landlord, to cover the entire build-out costs. But can you imagine being 74 years of age and just to sell your clinic, right, you have to physically relocate. So the winning strategy behind it, as Paul will touch on from the employment side, from a lease side, start the process early. Have someone on your team that is working on a flat rate basis that's done it before and many times, and help to make sure that you're turning the tables on the landlord by starting early. Takes away that threat that, oh, well, if you don't sign this, your lease expires next month, and of course you're stuck. So the earlier you start, the better the results and the more leverage you have across the board. Finally, one of the best practices over 30 years of helping to support doctors with their leases and lease negotiations. Number one, get all the facts. If you don't have a signed and countersigned version of your lease, that might go all the way back to 1986 when Michael or his father helped you transfer the lease from the original buyer in 1986 or otherwise, right? That original lease is still probably the binding agreement, and then any amendments, riders, exhibits ever since. Number two, figure out your goals. When do you want to transition? What does that transition look like? Have you got your other employment contracts or other things in preparation for the sale? Have you had someone review your lease? From Paul's perspective, the employment contracts, to understand someone that looks at it all day, every day. Are you overpaying in rent? What are some of the risks? And how would we advise a buyer that might be an impact, that could be an impact, for example, if you had language that required you to return things to a pre-dental condition? Last but not least, market research. Know if you're overpaying in rent and go in with the facts, right? Then figuring out what that long-term carefully choreograph of a game of chess looks like before the sale, right? And then what have I not done? I have not picked up the phone and called the landlord. So please do not Drive into the clinic tomorrow, email your landlord and say, gosh, right, I want to renegotiate my rent. What do you think, Mr. Landlord? And skip steps 1 through 5. Then, obviously, negotiating financials and some of the business clauses, and don't stop, obviously, till you get that final form lease. From that perspective, we certainly appreciated this, and we're going to customize a few things as well. But really, from a perspective, one of the key things that's important is here, having your lease professionally reviewed. I just pulled up a quick poll as I pass it to Paul. If you are curious about the demographics, if you're overpaying in rent, or you've not had someone look at your lease over the past few years, quick button here that we would be happy to provide that in an appreciation of everyone's time for attending our CE course this evening, which will issue usually about 10 business days after the course, as an FYI. We will log this to you in our system. And even if you might not have a lease, even if you're in the process of opening or buying or building a new location, we're happy to support you across the board and get some good insights or location searches across that perspective. Perfect. On that note, Paul Martin, it is a privilege and an honor, sir. I will let you share from your side.
Okay, just give me one moment. Hold on. Actually, it says you're still sharing. There we
Yep,
go.
I have stopped.
Okay, there I am.
Perfect.
Okay, and just bear with me for one moment.
And again, our true appreciation. We know you're due in court tomorrow,
Yeah.
Paul. So, on behalf of all the attendees and our clients here, it is greatly appreciated because we're all busy. But certainly, if this can give some great insights on how to take some proactive measures and avoid some very costly and potentially large mistakes, we certainly appreciate it.
Thank you, Eric. And as always, it's a pleasure to work with your group. Eric and I frequently cross paths with clients of ours. Whenever we have a client who has an issue with a lease, we invariably send them over to Eric and his team there to try and help them. Their track record with our clients is I think probably perfect in terms of being able to assist and to take what Eric said and to just expound on that. Certainly when it comes to leases, I don't draft leases or to negotiate leases, but I do litigate over leases. And that is a situation you do not want to find yourself in as a dentist. You want to be proactive in negotiating that lease and any renewal clauses. Because if you get into the situation where you need to get into litigation or a fight with a landlord, the money that you'll spend to have that fight will be punishing. And if you haven't dealt with it properly, the law on leases is pretty unforgiving. So certainly, Eric, we appreciate the opportunity to speak with you here today and to continue to assist our joint clients and potential future clients.
Appreciate it. And
So I'm
sorry, just as a quick, already some Q&A coming through. If you do have specific questions, you can do anonymous or you can have it specific. We'll cover some Q&A if there's time, certainly at the end. So please use the Q&A across the board.
Thank you. Okay, and
Perfect.
just bear with me. On top of everything else, I am on the tail end of a cold, so my voice is a little bit hoarse, and I may have to stop to get some water at some point. So, as you can see from the title of my slides, I want to go over some employment law essentials for dentists. What I really want to get into today is some updates that have occurred in the law of employment contracts. That is a forever evolving area of the law. There's been some big cases that have just come out very recently that have once again changed the landscape. So I'm going to start with a bit of a crash course in why employment contracts are important, and then I want to get into some case studies about what has changed and help you as an owner to potentially issue spot if there's some potential issues with your contracts. So any good discussion on employment law starts with the law of wrongful dismissal. Um, Employees who are dismissed from their employment are typically, well, not typically, they are, so long as it's a without cause termination. And I'll get into the distinction about that after. But as a general rule, when an employee is let go, the employer must give them some form of notice or payment in lieu of notice. Okay. And the amount of that notice will vary depending on a number of circumstances. So the notice comes in two parts. There's the statutory component under the Employment Standards Act. The Employment Standards Act is the bare minimum legislation that employers and employees must follow in employment relationships in Ontario. Every dental office is governed by the Employment Standards Act. And also, there's a second component to this, which is common law. And Canada being a common law jurisdiction, we inherited our law from the courts of the UK many moons ago. The way our system works is if a court makes a decision on something, if someone goes to a trial, there's a finding, and a court establishes the law, then that law is binding across the province and potentially across the country. So the Employment Standards Act, like I said, this is bare bones legislation in Ontario. It sets out the bare minimums that you must follow for a variety of things. This is where you get the vacation entitlement, various leaves of absence, overtime, hours per week. Any of those bare minimum standards are covered in the Employment Standards Act. Included in the act is the bare minimum notice or payment in lieu of notice that an employer, including a dentist, needs to give to an employee when they end that working relationship without cause. And it's not rocket science. It can be reduced down to a chart. This chart is not found in the ESA. You just need to parse through it to figure out, okay, if someone's there this long, this is how much they're entitled to. So I always use this chart that I've put together. It's very simple. If someone's been with you for less than 3 months and you want to let them go, pursuant to the Employment Standards Act, you wouldn't owe them anything. And this is where this concept of a probationary period comes from. You always hear this. You're on 3 months probation. That's why it is 3 months. Once you pass, or an employee passes that 3 month threshold, then they start to get an entitlement to some form of notice if you want to end the relationship. So as you can see, it just grows with service. Between 3 months and a year, it's a week. Between 1 year and 3 years, it's 2 weeks. Between 3 and 4, 3, and onwards, up to a maximum of 8 weeks. So if someone has worked in your office for 8 years or more, the maximum entitlement under the Employment Standards Act is 8 weeks. And I want you to keep that in mind as we move forward. Now, as I said, there's two components to notice in common law jurisdictions. There's that statutory component. And again, I don't know if all of our attendees here this evening are all Ontario based, but in the event that someone isn't, or you're in Alberta or British Columbia or Manitoba or whatever it may be, these principles are the same. They may have different acts that govern the employment relationship, but at the end of the day, each and every act will set out some bare minimum notice. It's a little bit different per province. But at the end of the day, there will be an act and there will be a common law component. So I'm focusing on Ontario because that's where I practice. But for anyone who's tuned in from somewhere else, this will apply to you as well. So on top of the Employment Standards Act, there's this common law principle. Common law is judge-made law, as I explained previously. What you need to understand about common law is that there is no defined rule. So I couldn't create a chart for you like I did under the Employment Standards Act to say, on top of that, this is what the common law will give you. Okay? And that's because the judges and courts like to have discretion, right? They don't want to be bound by some hard and fast rule, or else they wouldn't have a job to do. So courts are much more friendly. That will be one thing that you'll start to understand. So that Employment Standards Act component, really, once you get past the first 3 years of employment, it's a week of notice or payment in lieu of notice per completed year of service, up to the maximum of 8 weeks. The common law likes to build upon that. Okay, so what the courts have said is that's fine. The Employment Standards Act sets out a bare minimum amount, but we as courts think employees who are dismissed from their employment are entitled to more. Okay, and so although I've said there's no hard and fast rule, no chart that can be created, having reviewed thousands upon thousands of employment law cases, dismissal cases over the years, you do start to see a general trend. And so what lawyers like to talk about is this concept of 1 month's pay per year of completed employment. typically up to a maximum of about 24 months. Now, that will vary depending on various factors, but that is the trend that you see. And lawyers like to have a common currency to trade in, is what I will say, because the majority of employment law termination cases settle out of court. Okay, and I think the rough statistic is 98% of employment cases will settle out of court. The reason for that is most employment lawyers who know what they're doing in the area will generally agree that if the person goes to court and has their day in court, the court's going to give them roughly a month per year of service. So you use that as a standard to try and negotiate out cases. Okay, but that can become quite onerous the longer someone is there. So you can imagine. In terms of what courts look at when trying to fix a notice period, they'll look at the length of service. That's really the most important one. But then they'll also take into consideration things like age. The rule being if someone was closer to, say, 65, even though there's no mandatory retirement anymore, but if someone's closer to that sort of tail end of their career and they're let go, a court may be inclined to give that person more notice because they'll recognize that when someone's in the twilight of their working years, it's going to be difficult for them to find another job. Now, of course, you cannot discriminate based on age in the province of Ontario. So an employer could, or a potential employer could never say to the employee, look, I would have hired you, but we don't hire people over the age of 62. No one's ever going to say that. But my experiences with my clients, they're extremely reticent to hire more senior employees and have them start fresh in their clinic. So that's one of the reasons the court will award an older employee maybe more notice than, say, someone who's 33 years old, just got into the workforce in the dental clinic a couple of years ago, worked somewhere for a couple of years. That person's going to be able to find another job. So they may not get the same generous entitlement from the court. So, knowing that there's these two standards, there's the Employment Standards Act that sets out a relatively favorable scheme for the employer, and then there's this common law standard that sets out a much more favorable scheme for the employee. How do you reconcile the two? Okay, you don't want to have to pay that common law entitlement if you can avoid it. Because again, you're really looking at a week per year of service, up to a maximum of 8, or a month per year of service with no actual defined cap. So the difference can be quite drastic. The way that you do this is you put into a contract that when you let this person go, you are going to give them the ESA minimum only. And you explicitly state that that's all they'll get, and they'll have no entitlement to common law. They won't be able to take you to court to get that bigger amount, and you'll have certainty of terms. And that's the gold standard for all employers in Ontario. I think I've been doing this with dentists, for 15 years at least, assisting them and putting contracts in place. I have certainly noticed over the years that dentists have become more wise to this. It's not a secret in the marketplace anymore that this is a good idea for dentists to have employment contracts. In saying that, you'll be shocked how many people still haven't done it. And certainly dentists I find who are at the beginning of their career, Eric, what you had alluded to, they don't know what they don't know, as they say. So, they get out of school, they associate for a couple of years, and then they want to start their own clinic or purchase a clinic. And they're just not wise to this reality that employment contracts are almost a necessity in today's marketplace. So when we get this done properly and you have a contract in place that limits the entitlement, the savings to an employer can be quite drastic. So let's take a case of an employee who's been working in a practice for 24 years. And, I see this more often than you might think. I see it in two separate situations. One is, an employer will have worked with someone for 24 years and they've managed to coexist that period of time. That dentist is unlikely going to want to voluntarily fire that person. If you've managed to live with each other for 24 years, you'll probably be able to manage to ride it out. But what often happens with more senior employees like this is a dentist will be looking to sell the clinic, and a new purchaser of the clinic will say, well, that's great. You've got a great patient base. You've got, a great clinic here, great revenues, but I'm not taking on the associated potential liability with a senior staff member. So I want you to let this person go before I purchase the clinic. Okay, that comes up relatively frequently. The other side of that is the purchaser buys the clinic, takes the employees with all the warts and moles, and then 3 to 6 months into owning the clinic, they realize they can't work with that person for whatever reason. Someone who's been there for 20 something years will typically be pretty set in their ways. What we often see with more senior employees post purchase is that they're pretty resistant to some young whippersnapper coming in telling them what they're going to do and how they're going to do it. And so you'll find that the purchaser after closing will want to get rid of a more senior employee. So let's take that scenario. Let's say that individual earns $1,000 per week. If no contract is in place, and either the vendor dentist or the purchasing dentist has to let that person go at some point, you're going to owe that person somewhere in the vicinity of a month per year of service, meaning you could be liable for up to 2 years of pay, 24 months or 104 weeks. Multiply that 1,000 by 104 weeks, and you've got a $104,000 problem on your hands. Now, if you are a vendor dentist and you have to take on that loss, that's going to eat into your profits from the sale of the clinic. If you are the purchasing dentist, you've just taken out a big loan with the bank, I'm assuming. You've had to deal with Saris and pay them a bunch of money to make sure your lease is fine. And you're pinching pennies. If you get yourself in a situation where all of a sudden lawyers are involved and you're getting nasty letters saying we're going to take you to court, unless you pay this amount of money, that can really cripple you and cripple your finances as a new owner. And when a business is purchased, it's important to keep in mind that employees will always get credit for the years of service. So if you're a buying dentist and you inherit this employee, it's not like you get to start fresh with them. Now, there's some nuance there that's probably beyond what we can get into today between an asset and a share sale. The majority of clinics are sold by way of a share sale, is my experience. So when a share sale occurs, those employees will all be given credit for their previous years of service. And so some of them are 24 years, they're getting that 24-year credit, 10 years, 10 years credit, whatever it may be. And again, you will have to honor that. There's no way, and I've had clients try and do this before, there's no way you can put a piece of paper in front of them to say, look, now that I'm the new sheriff in town, you're not going to claim credit for your previous years of service. Even if the person was inclined to sign some document like that, a court will just completely disregard it. So instead of paying that $104,000 to that individual, if you have a contract in place that says you are only entitled to that bare minimum standard, no common law, then keep in mind the maximum under the ESA is 8 weeks. So that same 24-year employee would only cost $8,000 to get rid of, as opposed to over $100,000 potentially. Those are big savings. Okay. And, this is a bit of a drastic example, but the logic applies right across the board. So, say someone was there only 12 years and you find yourself in the same scenario, you're still going to be paying out a lot more money than you should be paying that person, and it's completely avoidable. So that's the most important benefit of getting contracts in place with your staff members. Canadian courts allow us to limit the severance payment or notice payment. These terms are often used interchangeably. They allow this, but they're very finicky about it, which I'll get into in a moment. There is no reason that a dentist, whether you've owned your clinic for 2, 5, or 20 years, shouldn't be exploring putting contracts in place with your staff. It's just good business. It's like having an insurance policy or having a good lease. If you don't do these things to protect yourself in advance, you can end up paying big time when things go wrong. When you're buying or selling a clinic, in advance of that, well in advance of that, you should review your contracts and have a lawyer look them over for you. The reason being is I'm going to get into in a moment. Not all contracts are created equally. I, you know, I I've lost count of the amount of times a dentist has called me and said, my clinic is closing next week. I need to get contracts in place. You're not going to do it. It's not going to work. You need to give yourself significant lead time to go through this exercise because just as I've said over the years, I've noticed more and more dentists are doing this and realizing the importance. The flip side of that is that employees are wising up too, okay, and that they might not be inclined to sign something that's thrust in their face with a couple day deadline, right? So I always tell people, just like your lease, you might want to start looking about a year out, okay, to give yourself an ample time to figure out what the lay of the land is going to look like with your staff and contracts. So, drafting issues. As I said, not all contracts are created equally. Um, the courts have said you can do this, you can limit the amount of notice. But since 2008, there has been numerous cases, too many to count, where the courts have nitpicked these types of contracts, these types of provisions. And so what ends up happening is, the employer will have the contract in place with the employee. They'll think that they're secure and safe. And the employee, when they're let go, will say, well, I don't like this. I put in 20 hard years with you, and you're only paying me 8 weeks now that I'm let go. They'll go to a lawyer, and there's a variety of lawyer out there that will take these types of cases on. They'll typically do them on a contingency fee, meaning they'll say to the person, I don't get paid unless you get paid. So there's really zero skin in the game for the employee to not try this on. And so what we've seen over the years is various arguments being made by creative lawyers to try and get the courts to overturn a specific provision in the agreement and nullify it. So this happens, like I said, more often than I can count. And there's been some really big ones that came out over the last little bit that I'm going to get into, which will show you just how nitpicky the courts have become. Courts do this because they favor employees. Okay, courts want to help employees who are dismissed get their entitlement. They don't look at you as, this dentist who's an entrepreneur who, themselves may be struggling to pay bills and run tight margins on clinics. They just look at you as an employer. So they don't treat you any differently than they treat Google as an employer. Okay. So you don't get any leeway because you're a small business person yourself. So there are at least two common drafting errors that have been invalidating contracts over the last year. I'm going to get into no, sorry, over the last number of years. And then there is a drafting error case that just got finalized in December of last year, which has really sort of rewrote the law and all of this. So the first case is a case called Waxdale. Um, to this point, I've been dealing with without cause terminations. So there are two ways to dismiss someone in Ontario. You can let them go without cause or with cause. Without cause means, look, I don't really like working with you anymore, or, your performance just hasn't been up to where I need it to be over the last little while. And therefore, I think it's time for us to end the relationship. That's a without cause termination. You're not really firing them for a good reason. You're just acknowledging that the employment relationship has come to an end. The law says you can fire anyone for whatever reason you want, so long as it doesn't amount to discrimination under the Human Rights Code. Okay, so you could say to your employee, look, and I've had these cases, and I'm not picking on people who might choose to have tattoos or dye their hair a certain way, but there's certain people out there that might have antiquated notions about, people with purple hair in the workplace, or, visible tattoos in the workplace. And I've said to my clients who have come to me, and this happens relatively frequently anyways, look, you can let the person go. There's no act of discrimination there. They've made a choice to get a tattoo that's visible in the workplace and you don't like it. So go ahead. Okay. Or, I don't like the way she says hi to me in the morning and I'm sick of it. Okay, fire her. Do it, whatever. I don't have the payroll right now to continue having this many employees. Okay, get rid of the person. But when you do that, you need to give them that notice or payment in lieu of notice. That could be contrasted with a just cause or with cause termination. A just cause or with cause termination means the employee has done something so egregious that it allows you as the employer to end the employment relationship without giving them any notice or pay in lieu of notice. So examples of what would give you just cause to let someone go, it's if you caught them stealing from you, if you caught them performing some sort of insurance fraud in your office, if they assaulted someone in the workplace, those types of things, that real bad behavior, will give you just cause to fire that person and give them nothing. Now, this case in Waxdale um, seized upon this distinction between just cause and an ESA definition. And this is a complicated case, so I'm going to try and break it down to its essence. In this case, the employer, who would have been Swegon, in their employment contract said, if we let you go without cause, you don't get common law, you only get ESA. That wasn't what the court was taking issue with. They had a separate provision in the agreement that said, we can fire you for just cause for these reasons. And it set out a laundry list of things that they would assert would give them cause. The majority of things that they listed would not give them cause to fire someone. Cause is a common law issue. So the courts determine whether you have cause or not a contract. Okay. Now, this is one of these wonky distinctions between common law and the Employment Standards Act, as it is with the notice itself. The ESA says you don't have to give someone any notice when you fire them for a different definition. It has that definition there in the second bullet point. So, in order to avoid having to pay any of those weeks per year of service, the employee must be guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. The key terms there are willful. So, what this creates is a situation where someone has done something really bad in your office and you fire them for just cause. The employment standards threshold, that willful misconduct, is a higher threshold than the common law just cause. Okay, so it creates this situation where if you fire someone and they go to the employment standards branch of the Ministry of Labor, they may say, well, yeah, you fired them. Yeah, their behavior was terrible, but it wasn't willful. Okay. And so they might get their ESA pay, but a court might turn around and say, well, we don't care about this willful standard. The behavior was egregious. And so you're going to be let go and you're not going to get the common law entitlement on top. And so what ended up happening in Waxdale was that the court hated this just cause issue. They didn't like the idea of an employer trying to assert what cause might be when it would run afoul of this willful misconduct provision in the ESA. I can buy that logic, and ultimately we've all had to buy that logic. It makes some sense from a legal perspective, from a drafting perspective. But what the court did next was what really impacted employers in Ontario and the validity of employment contracts. The court said because that just cause provision runs afoul of the Employment Standards Act, then any provision that deals with termination in the agreement, even a healthy without cause provision, is going to be struck from the agreement. Okay, and that was a case that when it came out, It caused a lot of employment lawyers to shake their head because it just showed the extent to which the courts were prepared to go to strike out otherwise valid provisions. Okay, so that's the Waxdale case. You would be shocked how many dentists had that offending language in their agreements. Um, it was in vogue to put that in there for years for some reason. I always stayed away from it because, from a litigation lawyer perspective, um, I knew that you couldn't codify what cause is in an agreement. It's a court's going to figure it out one way or the other. So, but it was in a lot of agreements, and I still see it to this day. And if you do a review of your contracts, tonight when we're done and you rush off because you're worried, or you get to it on the weekend or a month from now, if you see any language in there that says just cause or with cause, then chances are you have a problem with that contract. And for all intents and purposes, it's not enforceable. So that's that case. Then there's another case that came out called Stevens versus Sifton Properties, which identified another avenue that courts will go down to try and strike out these provisions. So in this case, it had nothing to do with just cause or with cause or anything like that. In this case, the provision stated that when the employer let the employee go, then they would get their ESA pay, and that's it. Okay. What the clause didn't take into account is that there's a separate section of the Employment Standards Act. And keep in mind, the Employment Standards Act sets out lots of bare minimum standards. Okay, not just termination, vacation, this, that, a number of things, hundreds of them. What the Employment Standards Act says in another section is that when an employee is let go, the employer has an obligation to give them that 1 week per year of service, but they also must do several other things. And one of those things is to continue whatever benefits the employee was entitled to for that 1 week per year of service period. So in Sifton's, the clause in question was silent on the continuation of any benefits. And so Creative Lawyer argued, well, that violates the Employment Standards Act because the omission of the continuation of benefits is them trying to do an end run around a bare minimum standard. And if you try and contract out of the bare minimum standard, the court's going to strike the provision. So by simply leaving out a couple of words about continuation of benefits, the employee in this Sifton Properties case was able to have the contract invalidated. And by invalidating it, they get the common law entitlement. So instead of that week per year of service, all of a sudden, a surprised employer is on the hook for months per year of service. Okay, simply because some little language was missing. I kind of went backwards there, but the point is the same. And since that case has come out, creative employer side lawyers have tried to argue in subsequent cases, well, this case doesn't apply because my client didn't have any benefits anyways. Okay, and lots of dental clinics don't carry benefits for their employees. It's not as common as it might be in other industries. What the court has said, we don't care. Any theoretical violation of the Employment Standards Act, whether or not it applies to that specific situation or not, will invalidate a termination clause in an agreement. So again, if you go home, now you've got two things to look at. Do your agreements mention just cause? And do your agreements mention benefits? And if they're silent on the continuation of benefits post dismissal, then your contracts are not enforceable, and you are a sitting duck if you want to let one of your employees go over the next little while who has that type of language or that missing language. Now I want to just clue up with what I consider to be a very surprising case. Eric, we did a seminar, I think back in January of last year, where I touched on some of this as well, amongst other things. But this law, and I distinctly remember saying at the end of that I cannot see how the courts can go much further with trying to attack these provisions.
Surprise.
And yeah, look, I'm wrong sometimes. My wife tells me on a daily basis that I am. So I was wrong. Okay. So last year, a case came out that subsequently ended up at the Court of Appeal in December. Okay, so a decision was rendered in December from the Court of Appeal, which means it's the law, it's binding. Once something goes up to the Court of Appeal and it's been challenged and the Court of Appeal doesn't overturn it, then we are stuck with it unless they go to the Supreme Court of Canada, which I'm not aware that this person is going to do that in this case. So I just in this for this case, what I've done is I just plucked the termination clause out of the case law, the contract that was cited in the case. And on the face of it, it looks perfect. It looks absolutely perfect. If you had asked me a year ago, is this enforceable? I would have said, of course it is. It hits everything that we've talked about. Okay, you'll see they're saying that they're going to give them base salary. They mention the Employment Standards Act. Clause 2 talks about the continuation of benefits, a post dismissal. 3, make sure that they're given all their payments up to date and that they'll get any entitlement to salary continuation. All the things that I would have said hit the right checkbox are in this clause. Okay. But what the court did is seized upon 3 words that I have underlined at the beginning. So it says the township may, and the township being the employer in this case, may at its sole discretion and without cause terminate this agreement. And sorry, my own box is there in front of that language. Terminate this agreement and the employee's employment thereunder at any time. Okay, fine. I've seen that language for 15, 16, 17 years. What the employee or their lawyer argued in this case was that, well, no, you can't. You can't terminate someone at any time because in the Employment Standards Act, there are a number of job protections given to employees who take certain types of leaves of absence. So if you were to take parental leave, then you're entitled to job protection. If you're going to take family caregiver leave because you need to take care of an elderly parent or a child who's become severely ill, then what the Standards Act says is you are entitled to job protection. So the employee argued that this violated the ESA because it's saying that by saying you can fire me at any time, you're saying that you can fire me when I'm on one of these job protected leaves. And the court agreed. The court agreed with them and said, yeah, that again is another violation of the Employment Standards Act. And once you violate the Employment Standards Act, you get the X right through the provision. So once again, an employee who was let go challenged the case, took it all the way to court. There was a trial about it and got the right judge on the right day. And the employer is left holding the bag. So the employer now, because of this case, instead of having to pay out that bare minimum standard that they baked into the agreement, will have to pay this person common law notice. Lots more money, simply because of 3 little words that look extremely innocuous on the face of it. So
The Q&A is blowing up, Paul.
and look, I mean, I've seen since that case came out, I would say 98% of contracts that I've looked at have that at any time type of language in it. Meaning, if you are an employer and you have had your contracts reviewed more than 4 months ago, you need to have them reviewed again. So that again will show you the extent the courts are going to go to try and invalidate these clauses. The best we can do when the courts do something like this is just retool, right? And that's why we have these sessions to try and inform and educate dentists as best as possible, and just to make sure that you're always checking under the hood, right? It's good business practice to check in from time to time with, a lawyer, any lawyer who does this type of stuff to say, look, has there been any updates in employment law over the last little bit. I get those types of messages from current clients all the time. And it's a 2-second email from them. And if there's been no changes, I say, nope, you're fine. Your contracts are good. That's it. That's the end of the exchange. Or when something like this happens, I'll say, we need to have a chat again. Okay. And let's get to work and figure out how we can clean this up. Everything can always be cleaned up. It's when you are stuck in a situation where you're being reactive to something that's already happened where you get yourself in trouble. So you fire the person, you didn't check with a lawyer, you just thought your contracts were going to be fine because you had them done a couple of years ago, and then you get a big surprise like this. So be proactive with any of the agreements that you're entering into with anyone, whether it be your landlord, your employees, suppliers, anyone. Be proactive, get things looked at, and do periodic checkups on them. Okay, so I will not say this time that I think the courts are done attacking these contracts because you just can't be certain, right? And someone may come up with a more creative argument down the road where the court wants to nitpick another section of these. You can't avoid it. You can only stay on top of it.
Paul, thank you. Um, One gut punch after another as we go through. So lots of Q&As. I'll just pull them up quickly in the essence of time. Also, quick little exit poll. If you are or would like more information or like to be contacted by Paul or one of the members of his team, etc., and you're concerned about your employment contract, there's a little section here at the bottom. As well, for those of you that haven't had your leases looked at or compared your rent to market price, or have looked at the demographics, we're happy to set that up as well. So one of the big questions here that has come through, Paul, is two scenarios. Is the big one. What if the employee doesn't want to sign this contract that says they get ESA minimums? So when I followed up with that, as you were speaking, I said new or existing client or employee, and they said both. So from a new, right, a new employee, I think I know what you're going to say, but the existing one is also an interesting conundrum.
Okay, well, a new employee, if you present them with a contract before they start and they won't sign it, that would be a major red flag to me. I would just simply not hire that person. And I would put that into practice in my own business. I'm an entrepreneur just like you. At the end of the day, I run a business. I have employees. If I was hiring someone and they said to me, "I'm not signing that contract," I would say, "Okay, thank you for coming out." No way. I would not take that person on. A, you're setting yourself up for legal risk, and B, the person has illustrated to you that they're going to be trouble. More commonly, the issue becomes with an existing staff member. And as I said, staff members over time have sort of wised up a little bit. Their rights at employment law are only a Google search away. They don't need to go to a lawyer like they might have had to at some point in the past. Now, any self-represented employee is going to muck it up at some point, but they'll get the gist of this if they want to look into it. There's two ways you can do it. One is you can offer the employee something in exchange for signing the agreement. Okay. And you'd be surprised how many people will sign a contract for a pretty small bonus. Okay. So we often typically say start at around $500. So say to the employee, look, I need to, and you have to finesse this a little bit, right? You don't go slam it on their desk with a check for $500 and say, sign and I'll give you the money. You need to have a meeting with them individually, go over this. And I typically help my clients and coach them a little bit in the language that they should use to try and massage this. And you'd be surprised how many people will take the money and run and sign the agreement. If they do, that's it. It's in force. It's done. That's a completed contract. If the employee says, "Well, I don't want your stinking money. I'm not signing anyways," there is another way you can do it. Where back to that concept of common law notice, that month-ish per year of service, you could say to the employee, "I understand that is your choice, but I do need to get this done. And so I'm giving you notice that in X months' time," so say the person was there for 10 years, "in 10 months' time, our arrangement on the current terms is going to come to an end. And if you would like to continue working with my practice thereafter, I'm going to need you to sign an agreement." And if they still say at the end of 10 months, "Look, I'm not doing it," well, then the relationship is over, but you've already given them the notice they would be entitled to. So they can't come back on you and try and get something else. I won't beat that point to death too much, but it goes without saying that if you've given someone notice that their employment is going to end. Um, you could be dealing with some issues during that notice period, that 10 months. It could be insubordination or just tardiness or absenteeism. We always help our clients manage that. And we'll get the employee back in check one way or the other. So, um, to answer your question, if you're dead set on getting it done, you will get it done.
Working notice is a fantastic component and is a great piece where again, if it's not someone that's dramatically impacting the business negatively, etc., right? The ability to give that working notice, right? So the employee has sufficient time to look for a new location, new place of business, etc. It's definitely a great best practice.
Yeah.
Um, Perfect. Yeah, thank you for that. One question earlier was from your past experience, what happens when you're consulted and there are some of the clauses and you mentioned, but the landlord says to take it or leave it? I'm sure other dentists will buy in, but would it be better than nothing scenario, right? Better than take it or nothing scenario? Or do you usually leave it and look for other opportunities? So, from a lease negotiation tenant advisory perspective that we do here at Cirrus is sure, right? Landlords in many cases, if they're dealing with the doctor directly, landlords love to try to dial things up and dial up the pressure and oh no no no, we don't negotiate, we don't work with any third party, we don't, you can't get any help, etc., just sign it or else, is a typical knee-jerk reaction that, again, just like Paul had shared, some people, oh, here's a standard form employment contract, just sign it, right? As if you're an associate, for example, right? Yet negotiation occurs, so no different than the lease, right? Most landlords, brokers, etc. Oh, here's the standard form lease. Oh no, no, it's standard, sign here, right? Well, of the 20 odd thousand leases we've seen, there's not two that are identical. So with that being said, there's always some specific nuances depending on the landlords, etc. So bottom line is we always typically advise a lot of our clients don't engage directly with the landlord because you can lose some of that leverage. And if it is a take it or leave it scenario, stop, right? Pick up the phone, have a different conversation. And in many cases, as Paul mentioned, and I touched on earlier, it's sort of that carefully choreographed game of chess, thinking well ahead, design the process, etc. If the landlord says 2 years out, no, it is what it is, take it or leave it, sign here or else. Well, heck, you got 2 years to start looking for other opportunities. So hopefully that addressed that key question. Um, Paul, lastly, for doctors thinking of transitioning in the next 5+ years, what are some key things they should be doing today in order to help make sure that they've cleaned things up in preparation for a sale? Perhaps for the doctor that's always procrastinated or said, it's not really an issue. What's one extra piece to sort of push people in the right direction?
Well, I've just illustrated three cases that have come out relatively recently where the court has bent over backwards to try and help an employee. Um, I think what any dentist who has a transition on them on the horizon needs to do is they need to break out their contracts. And, you know, I've given you three cases where, you could probably spot the issue yourself by looking at the language. So if it talks about just cause, you got a problem. If you see that anywhere in that agreement, you've got a problem likely. If you're missing language about continuation of benefits post termination, then you've got an issue. And if your contract contains any language about allowing you to let them go at any time, or any variation of at any time, then you've got a problem on your hands. And so you need to get on top of this and have someone look at these for you. Even if you go yourself and say, well, mine doesn't talk about just cause, mine doesn't leave out the benefits language, and mine doesn't say at any time, so I'm fine. I'm going to put them back in the briefcase. I wouldn't do that if I were you. I've just given you three cases where the courts have nitpicked these agreements. There's many, 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 many more of them. So it doesn't take a lawyer very long, a good lawyer, um, to look at a contract and say yay or nay. And I'd get on top of that because if you leave it to the last minute, you're putting yourself in a very difficult situation. I outlined earlier that, a potential buyer might not want long-standing employees. A purchaser might want to get rid of them once they get in there. There's, a variety of situations where someone might be let go who has a lengthier tenure. If you're going to deal with this, you got to get out ahead of it. In the most extreme example, and I'll sort of marry two concepts that I've talked about here today, this common law notice issue and them not wanting to sign an agreement. So I told you, if they don't want to sign, you can give them notice that at a certain date in the future, their employment is going to end. Let's take our 24-year employee. Let's say you go and look at your agreements and you're 4 months out from a sale and they need to be redone. And so we go to that employee and say, well, here's a sum of money. Please sign this contract so that I can get this cleaned up before I sell. You wouldn't tell them that, but that's what you're doing. And they say, no, I don't want to sign a new one. Well, then you don't have sufficient time to give that person working notice before the sale of the clinic, because theoretically they should get 24 months of working notice. Now, there are ways around that, but it requires cooperation from the purchaser. You never want to put yourself in a position where you're giving the purchaser leverage, because typically cooperation comes at a price. So, if they say, we'll help you get this cleaned up, but you got to knock off some money on this price, or you need to take responsibility for any termination costs post closing for X period of time. So the takeaway being, if you've got a sale of your clinic or a closure of your clinic on the horizon in the next couple of years, I'd break out those agreements and start looking at them now.
Perfect. Excellent. Paul, I know you're doing court early tomorrow. We appreciate the time. We know you're still in the office, and truly appreciate all the great guidance, advice. And again, doctors, you're not alone in all of this. If nobody's pat you on the back to have weathered through the previous storm, over the past 5 years, you certainly deserve it. And again, to be able to reach out to Paul or his team to get a better understanding for what the agreements are, and he's done it before, right? So here's the scenario. Here's what to do with the case of this employee, this employee, this employee, this employee, and here's what the cost is. Here's the process, right? You've got someone in your corner that's done it many, many times before. And Paul, thank you so much again for your time. Greatly appreciate it, sir.
Okay, I appreciate it. Thank you. Thank you very much for having us, and thanks to Sarah's for hosting us tonight.
Perfect. Thanks, everybody. Have a
Thanks,
great
everyone.
day. We'll be in touch soon.
Okay, bye-bye.
Thanks, guys.